The border question. The man at the customs booth had been working the same shift at the same port of entry for 9 years. He knew the rhythms of the crossing, the early morning commercial trucks, the mid-morning family vehicles, the afternoon rush of workers cycling back across. He knew which cars to wave through and which to pull into secondary inspection. He knew the system better than almost anyone working that stretch of the Texas border. He also knew exactly which vehicles not to flag. At 6:14 a.m. on a Monday, a white panel van crossed into the United States through a port of entry 70 miles southeast of El Paso. The van carried 4 men with valid documentation, tourist visas, legitimate on their surface, processed correctly in the system. The customs officer reviewed the paperwork, asked 3 routine questions, and directed the van forward without secondary inspection. He did not flag the passports for the extended biometric review that his supervisor's standing protocol required for vehicles matching the van's origin pattern. He did not run the secondary database check that would have produced a result he had been paid to prevent anyone from seeing. He closed the window of his booth. He watched the van pull onto the highway heading north. Then he picked up a prepaid phone he kept in the bottom drawer of his workstation and sent a single text message. 4 letters, no punctuation, a confirmation code. 72 hours later, the US Marshal Service received intelligence that a 4-person cell was operating inside the United States with a specific target. A federal judge presiding over one of the most politically sensitive terrorism prosecutions the Department of Justice had brought in a decade. The trial was 8 days away from sentencing. The judge had received threats before, routine for a case of this profile. But this intelligence was different. This was not a threat. This was an operational plan, already in motion, with assets already inside the country. The cell had been in the United States for 72 hours before anyone knew they were here. The case the judge was presiding over had been running for 14 months. The defendant was a mid-level financier connected to an Iranian-linked network accused of moving funds through shell companies to support operations targeting American military personnel overseas. The prosecution had built a meticulous evidentiary case. The defense had fought every motion. The trial had attracted significant media coverage, significant political attention, and, as the Marshal's Threat Assessment Division had noted at the start of proceedings, significant attention from parties who had a direct interest in seeing it fail. Iranian intelligence services had monitored the trial from its opening arguments. That assessment came from a joint NSA and CIA analysis shared with the FBI's Counterterrorism Division 6 months into the proceedings. The analysis noted that the trial represented a meaningful operational and propaganda threat to the network being prosecuted. A conviction would expose financial infrastructure that had taken years to build and would produce evidentiary disclosures that could compromise active operations. The assessment recommended enhanced judicial security. The Marshals had implemented an elevated protection protocol. The judge had been briefed. What the intelligence community had not assessed, what no one had assessed correctly, was that the decision to move from monitoring to active interdiction had already been made. It had been made 4 months ago, at a level of the Iranian intelligence apparatus that was not generating signals the analysts were reading. The plan that had been authorized was not a threat designed to intimidate. It was a removal. The judge was to be killed before sentencing. The trial would collapse. The defendant would seek a mistrial. The network would survive. The cell had been selected, trained, and equipped before it crossed the border. The corrupt customs officer had not recruited them, had not planned the operation, had not chosen the target. His role was one function in a chain: make sure 4 specific men with 4 specific documents crossed at a specific time on a specific morning without triggering secondary inspection. For this, he had been paid $80,000 over 14 months, routed through a currency exchange business in Houston that the FBI's Financial Crimes Unit had been watching for different reasons entirely. The payment chain would not be fully reconstructed until after the operation was over. In the moment, at 6:14 a.m. on a Monday morning, he was simply a man in a booth doing what he had been paid to do. The 4 men in the van drove north. They had a safe house address, a vehicle change location, a logistics cache, and a timeline. They had photographs of the judge taken from publicly available sources, conference appearances, a law school commencement address, a local news segment about courthouse renovation. They had the judge's publicly listed home county, which narrowed the residence search to a manageable radius, and they had 8 days before sentencing, which their operational planner had assessed as sufficient time to establish surveillance, identify the approach window, and execute. 8 days, and they had already used 3 of them before the Marshals knew they existed. The intelligence that broke the operation came from a source that had nothing to do with the border crossing. A Homeland Security investigations analyst working a separate financial crimes case in Houston had flagged an unusual transaction pattern at the currency exchange business, not because of the customs officer's payments, but because a different account at the same business had triggered an anti-money laundering alert. In the process of pulling the business's full transaction records under a court order, the analyst found the payment chain. It led to an account tied to a name that appeared in a Treasury Department sanctions list under a different spelling, a transliteration variant that the automated system had not matched, but that a human analyst recognized after 17 minutes with a reference document. The analyst filed an emergency escalation at 9:47 p.m. Wednesday. By 11:15 p.m., the FBI's Counterterrorism Division had connected the payment chain to the border crossing, cross-referenced the customs officer's shift records against the known cell's estimated entry timeline, and identified the vehicle. The van had been captured on 3 highway traffic cameras between the port of entry and San Antonio. The last camera capture was 61 hours old. The van's current location was unknown. The Marshals were notified at 11:58 p.m. Wednesday. The cell had a 5-day head start. They were somewhere inside the United States, in an unknown location, with an operational plan in progress and a target who would be walking into a federal courthouse in 5 days for a sentencing hearing that the entire nation was watching. The Marshals Judicial Security Division duty commander convened an emergency call at 12:30 a.m. Thursday. The calculus was immediate and brutal. The judge could not be told in a way that might cause a public reaction. The courthouse schedule could not be visibly altered in a way that might alert the cell that the operation had been compromised. The protection had to be enhanced without the enhancement being detectable, and simultaneously, the cell had to be found before it reached operational execution, before it acquired a firing position, before it established a sightline, before it got close. 5 days possibly less if the cell had accelerated its timeline. The judge's daily routine was the first thing the marshals locked down. The judge drove to the courthouse from a residence in a suburb 23 miles out. The route had 3 primary variations and took between 31 and 47 minutes depending on traffic. The judge had a consistent departure window between 7:40 a.m. and 8:15 a.m. and a consistent arrival window at the courthouse parking structure. The route passed through 4 traffic light clusters, 2 school zones active during the morning window, and 1 section of 4-lane divided highway with a half-mile stretch of limited sight lines to either side. That stretch of highway was, in the marshal's immediate threat assessment, the single most dangerous point in the judge's daily movement. A vehicle positioned on an overpass or in the brush on the elevated embankment to the east could establish a line of sight to the highway below for approximately 40 seconds during the judge's transit. 40 seconds was not a long window. It was long enough. The judge's vehicle was changed at 4 a.m. Thursday, replaced with an armored transport that matched the original car's make, model, and color, closely enough to require a direct comparison to distinguish. A decoy vehicle, the original car, driven by a deputy in protective gear, began running the route at irregular intervals starting Thursday morning. The judge's departure time was randomized within a 40-minute window each day. The route was varied by a rotation pattern the deputies managed internally, never repeated in the same sequence twice. The judge was briefed at 6:30 a.m. Thursday. The briefing was conducted in the judge's home, with the curtains drawn by the deputy commander personally. The judge asked 3 questions: whether the trial would continue, whether the courthouse staff would be protected, and whether the intelligence was credible enough to take seriously. The answers were yes, yes, and yes. The judge nodded and said to do what needed to be done. The sentencing would proceed. The marshals would find the cell first. Finding a 4-person cell in a metropolitan area of 2 million people, with a 61-hour-old vehicle trace and no current location data, required the kind of coordination that strained every resource the operation had. The FBI Counterterrorism Division established a fusion cell at the San Antonio field office at 2 a.m. Thursday. Every available surveillance asset was reoriented. The van's last confirmed position, the highway camera 61 hours prior, was the anchor point, and the search geometry expanded from there based on drive time radius analysis. If the cell had continued north from that point, they could be in Dallas, Oklahoma City, or further. If they had stopped, they were somewhere in the San Antonio-Austin corridor. If they had backtracked south toward the target, and the judge's courthouse was 280 miles north of the border crossing, they had likely passed through the search area already. The vehicle change location was the key. Operational cells of this type rarely kept a border-crossing vehicle for the duration of a mission. The van would have been abandoned or exchanged. Finding the van would anchor the cell's operational geography. It would tell the marshals where the cell had established its base. 43 law enforcement personnel across 6 agencies spent Thursday running every traffic camera, parking enforcement database, automated license plate reader, and commercial parking facility record within the search radius. The van was found at 6:47 p.m. Thursday, parked in a long-term parking structure at a regional airport, 3rd level, northeast corner. It had been there since Monday afternoon, approximately 6 hours after the border crossing. The cell had swapped vehicles within 6 hours of entry. A forensic team processed the van in place. Inside, a partial set of fingerprints on the driver's side door interior, a food wrapper with a receipt from a highway gas station, time-stamped Monday at 10:22 a.m., 41 miles from the port of entry, 3 hours before they reached the airport. And, in the wheel well beneath the rear cargo floor panel, a folded paper map. The map was a printed street grid of the metropolitan area containing the courthouse. 3 locations were marked in pencil. One was the courthouse itself. One was a residential area in the judge's home county. Not the exact address, but a 5-block radius that contained it. The third was a commercial strip 12 miles from the courthouse on the Western Approach corridor. The commercial strip. That was the operational anchor. The FBI had the commercial strip under full surveillance by 9 p.m. Thursday. 12 agents positioned across the area. Traffic cameras reviewed for every vehicle that had accessed the strip since Monday. A rental property above a dry cleaning business on the strip's north end had been leased 14 days earlier under a name that came back clean in domestic databases. The HSI analyst, who had broken the payment chain, ran the name through the international variant database at 9:44 p.m. The name was a transliteration of an alias, documented in a European counterterrorism file from 2019. The FBI hostage rescue team was wheels up from Quantico at 10:30 p.m. Thursday. They landed at 1:15 a.m. Friday. The Marshals coordinated the perimeter with local SWAT from 1:45 a.m. The target location, the rental above the dry cleaning business, was confirmed, occupied via thermal imaging at 2:10 a.m. 4 heat signatures, all present. No movement suggesting they were preparing to leave. The entry was executed at 3:47 a.m. Friday. Clean breach, interior clear in 4 minutes. All 4 cell members taken into custody without shots fired. The safe house contained operational materials, surveillance photographs of the judge's vehicle, and courthouse. A handwritten schedule derived from 4 days of observation. 2 rifles broken down and packed in foam-lined cases, and a communications device with an encrypted message queue that the NSA technical unit later assessed contained coordination traffic with an overseas handler. The cell had been operational for 4 days. They had conducted reconnaissance. They had a vehicle. They had weapons. They had a timeline. Their operational window, the slot they had identified as the highest probability execution opportunity, was the following Monday morning, the sentencing hearing date, the judge's most predictable courthouse arrival in the entire trial calendar. The Marshals had taken them down 4 days before that window opened. The customs officer was arrested at his home at 4:15 a.m. Friday, 30 minutes after the cell was secured, coordinated to the minute to prevent any possibility of a warning transmission. He came to the door in a bathrobe. He did not run. He did not deny anything. He sat down at his kitchen table and asked how they had found him. When the agent explained the financial chain, the currency exchange, the sanctions list variant, the 14-month payment trail, the customs officer was quiet for a long time. Then he said he had believed the money was for something different. He said he had been told it was connected to smuggling operations. Not this. He said he had not known. The investigation that followed did not resolve the question of what he had known. What it resolved was what he had done. On 17 documented occasions, Over 14 months, he had cleared vehicles flagged for secondary inspection without running the required protocols. 14 of those vehicles were subsequently identified as connected to smuggling operations. The cover story he said he had been given, 3 were not. The white panel van on Monday morning was one of the 3. He was charged with conspiracy, bribery of a federal official, and material support. The prosecution argued at trial that the question of what he had known was secondary to the question of what he had chosen not to know. He had been paid to not ask questions. The jury agreed. The judge delivered the sentencing in the original terrorism financing case 12 days after the cell was taken down. The courtroom was at full capacity. The Marshals maintained an enhanced security posture for the entire hearing. 12 deputies positioned throughout the building, 3 armored vehicles in the parking structure, a helicopter on standby. The sentencing took 47 minutes. The judge read the decision in a steady, even voice that gave no indication that anything had happened in the preceding 12 days. After the hearing, the judge was escorted to the secure parking level. The deputy commander walked with the judge to the armored vehicle. At the vehicle door, the judge paused and turned to the deputy commander and said, "You didn't tell me how close it was." The deputy commander said, "No, we didn't," the judge said. "How close was it?" The deputy commander considered the answer for a moment. Then she said, "They had a window picked out. Monday morning, your most predictable day of the year." The judge was quiet for a moment. Then the judge said, "And you were in their safe house on Friday morning?" The deputy commander said, "Yes." The judge nodded and got in the vehicle. The alternate timeline requires very little imagination. A cell with 4 trained operatives positioned 12 miles from the target, with a confirmed surveillance schedule, 2 rifles, and a Monday morning operational window against a target with a predictable courthouse arrival during a high-profile sentencing hearing. The Threat Assessment Division ran the probability analysis after the operation closed. The document uses careful, technical language throughout. Its conclusions are not technical. Without the financial crimes, analysts flag on Wednesday evening, a flag generated by a completely separate investigation that happened to touch the same payment infrastructure. The cell would not have been identified until the operation was in execution. At that point, the Marshals' options would have contracted from 4 days of proactive surveillance and a controlled takedown to a reactive response to an active attack on a federal judicial officer. The customs officer's 17 cleared vehicles represented 17 moments at which a human being chose to accept payment in exchange for not doing his job. On 16 of those occasions, the consequences were crimes that did not include murder. On the 17th, the consequence was 4 trained operatives inside the United States, 4 days ahead of the intelligence community's awareness, with a map that had 3 pencil marks on it and time enough to act on all 3. The third pencil mark, the residential area in the judge's home county, was never fully analyzed for its operational intent. The cell's communications, the safe house materials, and the interrogations that followed were not conclusive on whether that mark represented a secondary target, option, or a surveillance point. The Marshal's assessment chose to treat the uncertainty conservatively. For 60 days following the operation, the judge's home protection detail remained at elevated status. The route variations remained in effect. The armored vehicle remained assigned. The sentencing was over. The trial was concluded. The cell was in federal custody. The customs officer was awaiting trial. The deputy commander's team ran the threat posture review at day 60 and assessed that the specific operational threat had been neutralized. The enhanced protocols were stepped down in stages over the following 2 weeks. On the last day the armored vehicle was assigned, the deputy marshal driving it asked the judge if there was anything else needed. The judge said no. The judge said, "Thank you." The deputy said it was the job. The judge said yes, but still the vehicle pulled away. The judge went inside. Monday morning came and went without incident.